Round 3. 2.5.
Jury's coming in.
Please be seated. Yes, please. Okay. Ready, Madam Clerk?
Great.
We'll go on the record in State versus Pettit, CR 2022-425. We'll have the presence of counsel, the defendant, and our jurors. Thank you, jurors, for coming back. Okay, Ms. Evans, you may call your next witness.
State calls Deputy Wingett to the stand.
Deputy, if you want to make your way up, before you get there, I'll have you sworn in by the clerk.
I'll just stay at the desk to make things easier.
Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Come on over and have a seat, sir. Okay, Ms. Evans.
Can everybody hear me all right sitting at the desk? Okay. Deputy Wingett, would you please state your name and give your badge number for the record?
Yes, Deputy Adam Wingett, badge number 1135.
Can you please give me a brief description of your training and experience?
Sure. I've been with GCSO for approximately 6 years now. Training experience, I've had all kinds of training, all kinds of experience. Not so much with interviews and interrogations, that's more just experience. I have special training in a lot of tactical things that probably don't apply today.
Alright. So, I guess that'll answer some of my next question. So, let's move on to what happened in this case then. So, on or about July 5th, 2022, did you get a call from an attorney by the name of Joel Sanas about a violation of an injunction against harassment?
Correct.
And what did you do after you got that call?
Just reviewed evidence.
And what evidence did you review?
So the scope of my investigation was pretty narrow. We have a really big trial, and realistically, the only 3 or 4 pieces of evidence I'm looking at was 3 emails, an injunction, and I believe 1 screenshot of a Facebook post.
Sure. And quick question, is the Miami Unified School District located in the jurisdiction of Keogh County Superior Court?
Yes.
What did you do after you collected and reviewed the evidence?
Typically you want to start setting up interviews with people. So I believe I did visit the defendant's office to schedule an interview.
And when was that interview scheduled?
I don't have the date in front of me.
Does July 10th, 2022 sound about right?
That sounds about right.
And where was that conducted?
Conducted at our office here in Glen.
And who was present during the interview?
Myself, obviously, the defendant, Ms. Pettit, and her husband. Sorry, I don't know his name.
And did you record that?
I did.
Was it an audio recording?
Yes.
And have you reviewed that audio recording?
Yes.
Did you review a redacted version?
I've been notified that some of it has been redacted.
Is it still a fair and accurate representation of how that interview went aside from the redactions?
Yes.
State moves to admit exhibit number 24, state's exhibit number 24.
Mr. Cloud, do you have an objection to that?
I do not, Your Honor.
Okay, so exhibit 24, state's exhibit 24 is admitted.
The state would like to play it for the jury at this time.
And Mr. Cloud, you've had an opportunity to review 24.
Yes, sir.
And you don't anticipate, there's no objection to it being admitted, you don't have any objection to it being published in its entirety right now?
Correct.
Okay. So again, members of the jury, Ms. Evans is going to, and this is just an audio, Ms. Evans?
Yes.
Okay, so she's going to play you an audio. You're not gonna have the opportunity as you sit there to say stop or start. When you're in the jury room, you'll have access to this, and if you choose to listen to it additionally, you'll be free to do so. So our fingers are crossed that it will work as planned.
This is gonna be a voluntary, interview. With that being said, I'd like to make sure everybody knows their rights. So I'm gonna read them to you, you're not even being detained, all right? Technically, I only have to read them if you're being detained or arrested. You know, questioning you about, any kind of elements of the crime, or alleged in this case. So you do have the right to remain silent. Anything you say or do can and will be used against you in the court of law. You have the right to an attorney before questioning. If you cannot afford an attorney, one will be provided for you. So do you understand those? So once again, this is voluntary. You can leave if you want to. I just like giving people benefits of the doubt, especially in this circumstance, to be able to tell me their side of the story. Because I very much believe there's two sides of the story. So, let me just show you what I have, what was provided to me, and you can say yes, you can say no. I've more or less validated them. So we're gonna start out with, you were served on, let me see if it's got a served date here, June 27th.
I'm not sure what day, because I know she had come, she waited for a while one day, and I was in a patient room, and,
Let me look up the notes, I made notes. Okay, it was stamped June 27th, let me see what it was. Date of service, so June 30th at 10:53 a.m. That sound about right?
yeah.
So June 30th would have been, let me tell you right now, Thursday, so you probably would have been at work. Okay. So this is the injunction. We briefly went over the injunction. So I just want to, where are we at? So it says no contact, defendant shall have no contact with plaintiff employer or other person while that person is on or at court hearings and as checked. So they check the mark, email, fax, and mail. Does that mean you can call them?
It looks to me as though I can only email, fax them, or comply with the current.
Okay, so you can only email, fax, or mail.
Mail's
Oh, mail's not, other. I don't know what other means.
So other is it says it twice, but yeah, the one piece.
So I'm just going through this with you so I understand as well.
Okay, yeah.
So the first stipulation is comply with current or amended contact plan. Did you guys have a current or amended contact plan? Now, is that an unofficial contact
Yes,
plan?
it's not the personal or legal.
Okay.
Just gonna bring my computer and put in my keys and. We have a contact management plan, but it's just
So-
really long.
So I just wanna make this part very, very clear. I'm not arresting you on this.
Okay.
You're probably gonna have to go to court.
We are gonna go to court.
Yes, but I just wanna put you at ease. I'm not arresting you. Meaning I'm not booking you into jail. That's what I'm here for, kind of. So the first one is current or amended contact plan. You guys are, what did the contact plan stipulate?
in a nutshell, you know, on school property.
Okay.
On,
Now, just remember what you say is being recorded, so just make sure that it's fact.
So it says I'm allowed to be on school property. I used to call it a ban, and my attorneys say it's not technically a ban because they're giving me a way out of it. So what the contact management plan says is that if I have any need to be present on any days in advance to get permission. That's
So,
what
so
the-
events,
Any event.
okay,
Or
doesn't matter what the event is,
Mhm.
as long as you tell them beforehand.
2 school days beforehand, just a
Okay.
reminder on.
Okay, so that's number one, I mean, but according to this, they probably wouldn't disapprove it.
Right.
Use only this certain email address, has that been upheld? Have you been doing that? Okay. Email during business hours only, except in emergencies. So I'm gonna highlight ones that I have noticed that probably need some further explanation. No automated emails, this is probably the most specific injunction I've seen. No copy to students or parents on emails to the school. Nobody's alleged that you have, so I'm gonna skip that one. Only 1 email per subject, once again, nobody's alleging that. No personal complaints about school personnel unrelated to either defendant's child or school events. So that more or less means whatever is directly pertaining to you or your kid at the school.
I mean, I guess.
I'm assuming don't make a complaint on someone else's behalf, I think is what that means. Well, once again, nobody's alleging that. So my biggest 2 are gonna be right here, are gonna be the email during business hours only, and business hours, what did you guys stipulate as far as business hours?
I don't know that anybody stipulated, but I would assume is business hours.
Not necessarily, it's not just, what's his name, Lineberry, it's everybody. So whatever they deem as school business hours.
Yeah, it's gonna assume the school business hours.
Okay, well, if you were the school's business hours, what would they be? What is a reasonable time?
I guess when teachers are working, I don't know what time it is.
Okay. Is it safe to assume that it's probably not 1 AM? 2 AM, 3 AM, 4 AM?
It's safe to assume.
Alright. This has been covered. So essentially, what I'm gonna go over today is, we can start with the Facebook. I'm not gonna read all of this. This,
When I was talking to attorneys last week, they did say that I should have been also, served a notice of this hearing, the first one before this was granted.
that's probably gonna be something you're gonna talk to about court now.
So whatever you're about to read me, I don't know what is involved in this. I have this,
Which is
the
this?
injunction, and that's it.
Okay,
So it's Facebook thing.
Okay.
All of that, it's not for.
correct. Well, this is more motivation, more motivational is what I'm referring to, is somewhere in here you say, no, we'll just skip this. Because honestly, it doesn't really matter. Thought I had,
But essentially, it's the injunction that I posted on my Facebook.
is this the same injunction that's, what's the,
It looks like this is the start of the injunction, and then this is the sign, or this is the border.
okay,
But this is how we can.
so you do have,
So I just have the,
now did you appeal it?
so I'm going to on Tuesday, I didn't have all this information until I got with you, because we actually had our kid's birthday over the weekend, where we were, had a lot of kids with us over the weekend.
So you haven't filed for appeal yet,
It's not an appeal, but I haven't filed to request a hearing regarding this, but then.
but I think you only have 10 days to do that.
don't know.
I believe,
I read that it is, that a hearing happens within 2 days, and so I was going to do this on Friday, but I didn't look at my.
I think you just have to appeal in 10 days. I don't think the hearing necessarily has to be within 10 days. I could be wrong.
Well, I could be wrong too, but that's what I read. And
That's-
so I tried to do it online, they charge you $250, and then it was missing a signature, so. I'm not gonna choose the else. I'll make that. But also, like the court stuff and this injunction, I guess they're gonna be separate, unless you can appeal and like we have before.
Which one?
This injunction, I have to deal with this injunction before a federal case is filed because it's shoe marking, so.
Okay, so one they have to find standing and one to proceed with another. Well, I mean, I had papers. I don't know if they're all open. Okay, so I probably have to reprint them out. I was provided, 3 emails that were sent, one on first, second, third, or second, third, fourth, at varying times. 2, I believe, Lineberry, I could be wrong about that, but it just says school employee. Essentially, what we went over, the asking to attend school events. Not only were they not sent during what would be considered normal working hours, school's out. School's been out. You made mention that they were automated. It specifically says no automated. Do you want to cover that at all? Okay.
I know, we're all being recorded, so I don't know what I should say, because I've been maybe there, that I shouldn't say anything on that matter.
Okay.
I was told just to say what I've already said, take care of it, my IT guy set some things up, it's through an automated fashion, because, they have set such stipulation that I was worried about missing something from my senior students, so, we went through and we requested to attend any of the events.
Does he have any school events that would have been taking place that week? Or any event period for the school?
So, I'm not sure.
Hence the automated, regardless if there was or was not something, it was getting sent. Okay, do you see where that might be problematic? Especially since, so the reason I brought up the Facebook thing is because somewhere in here, once again, I'm not gonna find it in case I don't know how much difference it's gonna make anyway. You allege that you are essentially going to use automated messages to, I don't know the exact phrasing.
It's in an email, actually.
Okay.
It's not in the text.
Okay, so it wasn't mentioned on Facebook at all?
He's talking about,
I'm assuming we're talking about the same thing?
yeah.
I don't know what the heck happened out here. No, that's Donald. This is one of the emails.
This is your number 2 on the injunction, where it says, the emails will be sent automatically for any game of any sport for any grade and any event taking place on any of the state properties, just in case they want to attend.
Okay, which I don't think anyone has a problem with, minus the school's not even in session. No one should be getting involved.
Yeah, I think you're just talking about, so these are the
I'm talking about 3 very specific emails that I'm gonna try to pull them up here, so you can. Once again, sent on July, it was first, second, third, or second, third, fourth. One of the 2 at varying times throughout early morning, 1, 2, 3 a.m.
I think this is the reason for the injunction, and then the judge signed it on whatever day, and then he has, like, say, this was signed June 30th, now they only have from June 30th on to like make it.
So I don't care about any emails that were actually sent before June 30th at 10:57 a.m. because that doesn't make a difference. That's not why I'm here. I'm strictly here for the violation of court order allegedly. Now, if they were automated, did you have a chance to go through this when you were served? Did anyone explain, did you seek counsel from a lawyer the second you were served, or sometime during that day, or the next day, or?
During work day, right?
Okay.
So this was in front of all the patients and my staff, and, so I didn't even know what she was there for.
Okay.
So she came back to me. I have to be very careful, and we live in Glen, so it's not like even next day I can take care of stuff, because, this is a public school, which allows me attorneys outside of Arizona, and mine is in Pennsylvania.
Okay.
Different time frames.
Okay,
But he is the one that made me aware. I told him, I think I can take care of this, or just request the hearing. He doesn't need to fly and do all these things that cost meals, and I think I can request the hearing already.
So-
I've already submitted it, just was missing the signature.
let me print these out. I don't think there's any point in asking, do you remember signing them? Because I don't believe you knowingly sent them, as far as physically you were not the person to send them. So despite being one of the more specific injunctions I've seen, it was fairly easy to read. I mean, there was only a handful of stipulations. So this is what I was provided. Take particular note of the time and dates. I don't know what time school was out for the summer. But I can tell you that's not within a reasonable time frame to be sending emails. So that is mainly why I'm here. I need those back though. Did you want to address these or no?
So we already did address it, and we said to.
Automated.
We said, yeah, to get in there and make sure nothing else is coming out, and I think nothing else is coming out, but I honestly, it's in a different.
Where does
Where
does one send automated emails from?
So one uses a program called Lineberry.
Okay.
And it's I instead of bringing a laptop, but it's not even on the laptop, so
Okay.
for me to dig through there, I think that I got it, but I honestly don't even know totally how to tell, but I can tell you that I cannot see any recurring ones coming out.
So you don't know they're being sent? That's not a very good program.
I'm just saying that this one,
Yeah.
this one used to be all that was necessary of me forever. This is all that was sent every week until I realized they were automated. And then he had a big problem with it.
Okay.
So then it had to be specific to every single thing.
Yeah, I'm not gonna mention anything about I don't mind, whatever you guys settled is fine. I don't know why they specifically put automated. It's not my injunction.
One can't simply scroll through something that no people did.
Yeah, maybe it's because accidents like these happen, because you don't even know when they're being sent, therefore you.
Does it matter if it's sent, I mean, at 1 or in order to comply with the ban, there's 2 days, what is 2 school days?
Yeah, the only reason that automated messages are pertinent to this investigation is because it says no automated emails. That is the only reason. Why they had an issue with that, I don't know. I have to go off of what the judge says. Since then, have you corrected the problem?
I believe so, but I'm hesitant to say, if I haven't, I'll be arrested, I guess, I don't fully.
No,
through all of it.
I said this time you're not gonna be arrested. I didn't say you weren't getting charges, but you're not gonna be arrested. This is non-violent. I think the whole thing probably just needs to be talked about, but I do wanna read you some statutes.
In the injunction, I have a question that may be for you.
I may be able to.
On number 6, it says, defendant should be ordered to stay away from these locations at all times, even when I am not present. This doesn't really-
Number
I'm
6.
not present yet. Who's I?
I don't see number 6.
On the itemized. These are the reasons he gave to the judge to kind of.
Oh. This may be I is in Lineberry. I don't know who.
I'm assuming that his name is nowhere on this injunction to know who. I'm
Well, then
speaking from.
yeah, then I really wouldn't be too worried about that one. Do not lose, so residence, work, business. Yeah, so I'm not gonna interpret that. All I'm saying is nobody's alleging that you, didn't follow that specific stipulation.
Did all of these things in this 30-page contact management plan for a year and a half, so I
Okay.
put it to make consistent. I still have a kid in the district for another 4 years, and I've been a part of this district for more than 20. My oldest daughter is 27. All of them went through my own schools. I've never had a complaint. Now I'm tired of being controlled and bullied. I'm being bullied by this man, honestly. So it probably comes down to me being arrested.
It's okay, just relax, like I said, you're not gonna be arrested. Is this in your belief anyway, is this simply just a matter of who threw the first punch, as far as it's making you look bad because they got the injunction on you first?
I don't
Or
care
is
about
it-
looking bad anymore.
Right.
I don't.
No, I care about, once again, what's in the best interest of you and your family. And I can tell you, picking up felonies is not ever in the best interest of the family. Have you sought alternatives to make sure that you're not putting me in a position where I have to pick anymore?
I honestly don't think any more emails are coming out. I guess I don't
You-
know how to.
I need a little bit more of a commitment than think.
So I,
Delete the program, get rid of your subscription, because if this happens again, without a doubt, I'm gonna have to hook you for a class 5 felony. And I think that is ridiculous, but I'm not the victim, I don't get to choose. Court says I have to follow this, that's what I'm gonna follow. Alright? You need to make damn sure, not I think, you need to go call the company if you have to and make sure that there is no more emails coming out. Once again, have you contemplated alternatives
what do you mean?
as far as schooling?
I wish he would. I wish he would go somewhere else, yes.
Okay.
I also don't know how to handle it because
I don't either, nor am I recommending anything. Once again, my worry lies with you. I think this has gotten incredibly out of control. And
they already have targeted our youngest one, and he probably will end up going to Glen. But do you make him go away from his friends because this person needs to go with us? They could, this ban is.
but I'm not reading an injunction you put against Lineberry, the school. You see what I'm saying? They, in a matter of speaking, they struck first. So that's why I'm here, that's why you're here. Maybe next time, I mean, if you say this is going through court, it's gonna take some time. But until then, this is good for a year. and it's going to be followed for a year minimum. That doesn't mean they can't, I mean, if they went through the Superior Court for this, it's good for 2 years.
They did go through Superior Court, Great Maricopa, is that Superior Court?
Why would they go through Maricopa?
Because he doesn't want to.
Let me see when it's actually get to.
It says Superior Court.
That's weird. Does it say anywhere how long this is good for?
But apparently there was a trial, I didn't get to attend.
Okay, yeah, I don't know anything about that. That's something you're gonna have to bring up with the court. Date of service on 6/28/22. I don't see anywhere how long it's good for. I'm going to assume a year, but you might wanna check on that. Generally speaking, JPs are good for a year, and superiors are generally 2 years. But I don't see that here. I don't see anything. So please convince me that this isn't going to happen again. At least with the automated emails and anything like that. Facebook posts.
No, I think this is almost the end of the video. It's a little hard to hear, but at some point during that interview, you told her to delete the program,
Yes,
and in response to that, she said no.
that's what I heard.
Now, at some point you said to her you didn't believe she was doing this knowingly. What did you mean by that?
So, obviously the culpability here is intentionally. She intentionally set up the program. She intentionally meant for those emails to be sent.
So what you're saying is what you meant was she initially set it up, but after that she continued to allow it.
Correct. And
Not
it's-
that she sent these individually herself at the time. Is that about the extent of your investigation here?
That's about everything, yes.
Nothing further.
Mr. Cloud?
Yes, sir. Do you want us to use the podium or sit here?
Wherever you're more comfortable with, the jurors can probably, as long as they can hear you and your voice moves or carries, so that's good.
All right, thank you. All right, Officer Wingett, you first contacted my client on July 6th, 2022, correct?
That sounds about right.
And that interview was 4 days later?
Correct.
Okay. When you first contacted her, I was at her place of employment?
I believe so.
Okay. And during that first contact, she admitted she had set up automated emails?
I believe so.
And she said it was specifically through an app called Boomerang.
Yes, that's what she said in the second one as well.
And she also told you that she set up those emails in response to something called a parent contact management plan that was set up by the school. Do you recall that?
Yes.
Okay. And you never personally reviewed the parent contact management plan?
I did not. I didn't really review anything after the injunction.
Okay. Well, were you present here at this trial for my opening statement?
Yes.
Do you recall when I played like a short audio clip?
Yes. I can't quote anything from it.
Right. But would you agree that was your voice on that audio clip?
Yes.
And that was from the initial contact. This was from the second contact.
That's correct. Yes.
Okay. During that first interaction, you asked her about his automated emails going out, one went out the 3rd, 4th, 5th. Do you recall her responding, "I honestly don't know"?
It's something to that extent.
Okay. And then you said, "Are they automated?" And she replied, "They're automated."
Yes.
All right. Do you feel like she was being honest with you?
Doesn't matter what I think.
During the first contact, you set up the second one that we just listened to,
Correct.
and she voluntarily came down to the station and met with you?
That's correct.
She came there without an attorney?
Yes.
Actually, she brought her husband, I believe, right?
I believe so.
And I think you started that conversation with, I may misquote you, but you said something along the lines of, "There's two sides to every story."
That's correct.
Essentially, she told you the same things that she told you briefly in her office on the 6th.
Correct.
And during this interview, she said her IT guy set some things up,
Yes.
and that was in reference to the automated app called Boomerang.
Yes.
During the interview that we just listened to, did it become apparent to you that she didn't really know how to use the Boomerang app?
That's what she was alleging, yes.
Did you kind of clarify with her that she didn't know the emails were still being sent out?
I asked if there are more going out, is that what you mean? Or not?
Yes. Whether
Yes.
would emails continue to be sent out?
Yes.
And her response, I honestly don't even know totally how to tell, but I can tell you I cannot see any recurring ones coming out.
That's what she stated.
All right. And you confirmed you don't know that they're being sent out.
That's what I said.
And then you said that doesn't sound like a very good program.
Correct.
Ultimately, your conclusion at that time was that you didn't believe she knowingly sent the emails out.
That's what I stated.
You personally read the emails of July 3rd, 4th, and 5th?
Yes.
You take those by themselves. Is there anything offensive in them?
No.
Is there any threats in them?
No.
Anything intimidating in them?
Not at all.
You haven't had any involvement in this case since that interview?
I don't believe so, besides like a defense interview or something like that.
All right. Thank you, sir. No more further questions.
Any redirect, Ms. Evans?
Do you believe that she knowingly set up recurring emails?
Yes.
Do you believe it was her responsibility to stop them once they've been set up and she had a court order to stop them?
100%, and to take that a step further, the second my involvement happened, the email stopped. So that tells me she had control of it.
Nothing further.
Members of the jury, do you have any questions for this witness? Not seeing any. Okay, some of them are taking notes, but okay. Deputy, if you want to go ahead and have a seat back next to Ms. Evans. Ms. Evans, you may call your next witness.
State rests.
Members of the jury, the state has concluded their case. I'm going to need to handle a few things with the attorneys as our next step. It's only been about 35 minutes, but you're going to get your first break. Okay? Again, we're not in here just drinking coffee, eating donuts. We actually work at these breaks. I think during this break, I will most likely talk to the attorneys for a little bit, handle some matters, and then give my staff a break so that when we come back, we'll be ready for a full next session. It's probably going to take us about 25 minutes between those two things. If you could be ready, Gene will give you an update, let's say at 2:30, whether we're close or whether we're going to need a little bit more time. So I'm going to excuse our jurors. Again, you've heard the state's case, but you're still not to discuss the case amongst yourselves. You're not to do any research. I'll excuse you, and we'll see you back hopefully right around 2:30. Please be seated. I'll note the absence of our jurors. Counsel, just a quick housekeeping matters before I get to Mr. Cloud and if he has a motion. Counsel, like JA just provided you a draft of final instructions. Mr. Cloud, I'm not sure if that includes any of the ones you specifically requested. So,
We got jury verdict forms.
Did you get the email?
Oh.
did you? No, I thought she just. Oh, did you just get verdict forms? She may have just emailed you the jury instruction draft.
I haven't had a chance to look at it yet.
Okay, but it's coming. I just try to get it out as quickly as possible. Mr. Cloud, again, I'm not sure that they will have, if you ask for any specific instructions. I did take a first stab at an instruction indicating that other emails cannot provide the specific basis, but are admissible and may be argued for the context. You'll see that in there before the mental states, but after the specific description of the crimes. Again, my goal is just to get those started. And then the verdict forms are what was used at the first trial. Okay, Mr. Cloud, do you have a motion?
I do, Your Honor. Judge, I make a motion under Rule 20 of the Criminal Rules of Procedure. A judgment of acquittal is appropriate where there's no substantial evidence to support a conviction. Your Honor, in this case, I believe there's no substantial evidence that has been presented that my client knowingly or had any intent in sending emails specifically to harass Glen Lineberry. The emails sent July 3rd, 4th, and 5th were programmed in November of 2021, long before the injunction was served. The law is clear, the harassment must occur after the date of the injunction that it was served. That date was June 30th. The only thing that can be harassing in this case is my client's behavior after that specific date. The state has presented no evidence that my client intentionally sent emails after that date. I would argue that the emails, based on Officer or Deputy Wingett's testimony, that she could have gone back in and changed them, but it was recklessly not to, and that it was not an intentional act. As you're well aware, in the jury instructions, there is a jury instruction for voluntary act, and we don't have that here. It's jury instruction 35 if you're looking at them. I think that the state has presented no evidence, not even substantial as was required, but they presented no evidence as to my client's actual intent for those 3 specific emails. The entire bulk of the context of behavior before June 30th, in my mind, is irrelevant to whether her specific intent was either knowingly or intentionally on those 3 dates. Deputy Wingett testified he didn't believe he knowingly sent them out, or she didn't send them out knowingly. He also said, accidents like this happen. You don't even know they're being sent. That's my paraphrasing, not a direct quote, but Judge, accidents like this happen. She's served, she's at work, she's talked about how to finishing with her patients, she's a busy mother of 2, and she's married and supporting the home. Not going back, there's no evidence that that she knowingly, like she made a choice to not go back. So I don't believe the state's met their burden. I'd ask for the court to take this case from the jury. My second part of that motion is for to make a record. The court heard this issue at the last trial, but I need to make a record of it. Legally, Your Honor, an injunction against harassment is a different thing than injunction against workplace harassment. They are granted under 2 different and separate statutes. Now, the law before September of 2022 was a bit vague, and it did not specifically reference 12-1809 or 12-1810. However,
we've litigated this issue at least twice.
I'm just making a record, Judge.
The record has been made.
Ms. Evans, I'll allow Mr. Cloud to make records.
Thank you. Your Honor, the prior law was vague. It didn't specifically reference which statute it was applying to. Legislature corrected that in June of 2022 by specifically referring to 12-1809, which is an injunction against harassment. Now that law didn't take into effect legally until September in the fall of that same year, so the old law controls in this case. However, I believe the court's analysis should be the same. An injunction against harassment is a separate legal mechanism, a separate legal court order from an injunction against workplace harassment, and that this injunction in this case does not qualify under the aggravated harassment statute.
I'm going to affirm my prior order that an injunction against workplace harassment can provide the basis for an aggravated harassment charge. The court additionally will find that there is substantial evidence to support the conviction. Ultimately, what the jury does with that will be up to them, so I'm going to deny the Rule 20 motion as well. Mr. Cloud, do you need time with your client to determine whether she's going to exercise her right to remain silent or choose to testify, or?
She's going to testify, Your Honor. I would like to. Did you order in the back at what time? 2:30.
2:30. That way.
That's fine.
I realized we had a short session, but that way, once we get to Ms. Pettit's testimony or Dr. Pettit's testimony, we're not going to have to break after 20 minutes or something. We'll go right through it. Okay. Yes.
One last thing, Your Honor. During Mr. Cloud's opening statement and in some of his testimony or his cross-examination of Dr. Dorathy, he tried to bring up the letter that was sent out by Mr. Glen Lineberry to Justin's father. We have already ruled that is not relevant, it should not come in, so I ask that you remind him not to ask any questions with regards to that. I'd rather not have to continue to make objections as to relevance during the trial.
And is that related to the family law case?
Yes.
Okay. Mr. Cloud, do you intend to go into that?
I intend to ask my question. What started the initial argument with Glen Lineberry that led to the Facebook that led to the public, so
And I
it's
believe that's already been
explanatory.
ruled as irrelevant.
Mr. Cloud, I've already made a ruling that basically anything in advance of the parent communication management plan is not relevant. So I'm gonna go ahead and make an order now that anything conflict between the school and your client prior to that is not relevant to her actions in July of 2022. You can ask her about her background, etc., but as far as the conflict between her, Mr. Lineberry, the school, Dr. Dorathy, etc., I am going to grant I'll treat it as an oral motion and eliminate on that. Is there any additional record you'd like to make, Mr. Cloud?
Your Honor, I think that it's unfair to limit her testimony to not explain some of the things that were asked and implied and discussed with the witnesses, that answers from witnesses in the state's case in chief. My client should be given the opportunity to explain her actions that were discussed in the state's case in chief.
Ms. Evans, anything else then before we break?
No, Your Honor.
Mr. Cloud?
No, Your Honor.
Okay, and so we'll return back at 2:30, and then Mr. Cloud, I'll ask you if you'd like to call your first witness.
Thank you.
Okay, see everyone at 15.